How do people choose specializations? Is it based on their interest, or is it the money they could earn?
Money is not everything for which the person lives. You're good in your subject, money follows you. You are average in your subject, money still follows you because you can convince the judge.
You need to have great memory to remember so many sections, so much content, right?
Memory is something which is with everyone. We are no special species on the earth. Lawyers also are average human beings who have normal memory skills.
How long do someone have to take the internship, the duration?
You should have, I guess, 4 internships, or some law colleges say you should have 10 internships in your legal career or in your law school.
So people who pursue law, uh, do they have, if they don't want to practice and then get into specialization, what kind of jobs can they take up?
Every company which has raised, let us say, for about 50 crores of turnover will look for a dedicated legal team for itself. Now we call them as employees on roll for that company.
Welcome to MetaSphere podcast series. Today, we are going to have intense discussion on legal profession. We have Dr. Moksha Kalyanram Abhiramula to discuss about legal profession and the opportunities. Consider me with zero knowledge in law, so you have to help us to understand things at ground level. So please tell me, how was your journey? How did your journey start till date?
I'm also a beginner in law. Why I say this is law is an ocean like any other subject. Whenever you pick up anything, be it sociology, be it economics, be it physics, be it maths, all subjects are in themselves a research center for themselves. Now, when we see law, we have many branches. So we have corporate laws, we have arbitration, we have criminal law, we have civil law, and now Honorable Prime Minister is revamping many laws. So there is a meme which we have seen recently. Once you feel that you are thorough on a particular act, the legislation tries to revamp the whole act and give you a new act. That's what people feel. We are in a society where the entire aspects or the entire dynamics of the society keep changing in less than a month. Now, when something changes less than a month, we cannot have legacy laws. We need to have laws which are updated. Like if you see about 20 or 40 years back, no one knew that there will be a branch called cyber law. No one dreamt of something that could happen with respect to environmental laws as an exclusive branch. No one thought that there could be an arena of arbitration where you can have an international arbitration center in India, that too in Hyderabad. All this happened. Now they happened because the world is changing. World demands, law revamps. That's how things work. Yes.
What is your education background in terms of law? How did you take it forward?
Okay. I'm basically a law graduate. The basic qualification which is required is to be a law graduate. Now, law graduate, as per rules, is from a recognized university. So, we started off at Usmania University. Now, when I thought, why, the common question that comes is when I was studying my law, my faculties asked me, what do you want to become? I said, I want to become a lawyer. Now, he asked me an interesting question. You know what is the database of lawyers? It is as good as a population. What are you going to do in this stream where supply is high? He said, when supply is high, quality is the key. If I know what is my area of expertise and I give resolution to the litigants who come to me, I will be building a space in the most heavy supplied area. That was my statement long back. Today I stand to that statement. But when you see who can get into law, There are two options here. One, if in fact it is given by the Bar Council of India. Bar Council says there is an option of 5-year degree of law and a 3-year degree of law. 5-year degree of law, you need to be a graduate. Now, a graduate is a BTech, BCom, BA, or any BSc background. Anyone would fit for a 3-year law. A 5-year law is after intermediate. I'm basically an MPC background. I thought, in fact, it's not me. My father thought that I should be an engineer. My mother thought I should be a doctor. Finally, I became a lawyer. So it's not who thinks. What matters is what you think that you can become. That's what I strongly feel. So background is not the criteria. 5 years is a journey when you want to start immediately after intermediate, which will include a graduation degree for you. 3-year law is for those people who are already graduates from any university which is recognized and any stream. I have seen many colleagues of mine who are BTech, MTech lawyers. They have taken Bar Council membership. I've also seen people who have done their MSc and then did law. So it's interest. Now, interestingly, if you see, I have a colleague of mine who has done his MSc in agriculture. He completes LLB. Now he is addressing environmental law issues. There is a reason why someone has chosen that particular career. I have a person very known to me who started his business of electricity. So he is into building generators, transformers and all. Something went wrong, his business did not work. He had a lot of litigations from the LXT board. He went to many councils. Then he realized that it is better he completes law. He finishes LLB, gets Bar Council enrollment, fights his own cases. Today is helping people in LXT board and High Court for getting orders. It's a scenario where someone who has a business interest becomes a counsel. Someone who has an academic interest becomes a counsel. Someone who is focused on understanding or helping the society also becomes a counsel. So it's a choice. It's a choice where I don't say you want to serve the society, don't earn. Commercial angle and serving the society go hand in hand. And the rule of law says an advocate is an officer of the court. So we are here to help the court to understand the case and give a proper judgment. The responsibility which a judge has in pronouncing a judgment is there. Definitely, we don't dispute on it. But more than that, it is the responsibility of the advocate who is representing the case to the court to make the judge understand what are the issues involved, what are the facts, what is the legal point. Everyone is a student of law, be it a judge, be it an advocate, be it a person who is reading a judgment first time in his life. Because it's a notion. No one can claim that I have commensurate knowledge in law. We are seasoned people. Why we say seasoned people is we know many laws. Yeah, I know about 4 or 5 laws. That doesn't make me stand apart. What makes me stand apart is the depth of the knowledge which I have in the stream which I'm talking about.
So you're talking on the specialization, right? People wants
Right.
to help people. Your friend was helping in electricity board and all. So how do people choose specializations? Is it based on their interest or is it the money they could earn? How do you choose that area?
Money is required for the person to live, but money is not everything for which the person lives. Now, having said that, choice of a career should not be based on the commercial angle of it. Choice of the career should be based on the subject matter expertise. When you study law, now there was a question which we were talking to a couple of our fellow colleagues. I personally asked that question to my colleague. I asked him, we don't see dedicated training sessions for advocates, but we definitely have a dedicated training sessions for judges. We have judicial academies. We don't have advocates academy. He said we have. That is called law school. Now, my second discussion forum was, okay, we have law school, but then we have left law school almost decades back. Now, what is our training platform? He said our training platform is the court itself. That's our pitch, that's our execution zone, and that's where we learn also. Now, this is when you decide, when you are go to court regularly. Some cases you feel that this suits me, some cases you don't feel this suits me. There are courts in which we feel sleepy. I also feel sleepy in certain courts, not because I did not have sleep in the night, but then it could be that that subject which is being discussed in that particular court doesn't excite me. When you feel that a particular subject doesn't excite you, or a particular subject makes you uncomfortable, that is not the area of law which you can excel yourself. Now, classically, when I also went and attended a couple of the LXT cases in various courts. But whenever I attend, my sustenance time is 15 to 20 minutes. After 20 minutes, I'm detached to the court proceedings. I realize that, okay, this is not the domain which I should explore to excel. Now, when I go and sit in the court where bail matters are heard, I'm all alert. Serial number 95 is running, I'm as active as serial number 1. I felt that, okay, this is the area which I think I have area of interest. Forget about expertise, we're talking about area of interest for choice. Now, this is where, while doing practice, we have demarcated ourselves. Now, this luxury is there for students also. Students attend something called moot courts. And in moot courts, when we observe students actually getting into a moot court argument, most of the argument is predefined. And most of the argument given by the upcoming lawyers is in the form of a true extempore recapitulation of what they have studied in the case already. So by and large, what I can understand is they by heart, they make some serial communications, and then they try to vomit it in front of the moot court judge. Now this is where the PCI has also encouraged moot court competitions. But if someone seriously sees these moot court activities, it's an ideal replica of the courtroom where judge is a student, advocate is a student, client is also a student. Now all these students try to understand the behavior and pattern study in a courtroom. That is an excellent platform to understand which part of law motivates you or which branch of law motivates you. We have everything as a student. We study, what commonly we study is constitution because that is the foundation pillar of every enactment. Constitution, if it motivates a person, ideally the person should be a judge, not an advocate. Because constitution is the base research center of law. So if constitution really motivates you, you read the entire constitution and you don't feel sleepy, you are an ideal judge. As a student, we tend to sleep. I also slept when I was reading constitution because it's lengthier, and as any legal subject, you don't find pictures. It's not a magazine where you find a picture and that picture motivates or excites you. It's pure text. After some time, you get detached. So you have to, when you study, you take 3 or 4 acts. Let's say corporate law, then you take up criminal law, then you take up cyber law, then you take up civil law, then you have constitution. Read 3 pages here, 2 pages there, 1 page here. That's how you prepare. I'm not talking about exam. I am talking about preparing for the profession. Exam is, everyone prepares 3 months before or 3 months before the exam. That's the reason we have semester system where the time frame itself is 3 months so that we are in regular preparation. That's how BCI has decided. Now, once you complete all your 6 semesters, if it is a 3YDC, 10 semesters or 10 semesters if it is a 5YDC, you become an advocate. Now, during this period, you can decide which branch of law actually gave you or challenged your wits or created interest in you. My suggestion, explore in that. Commercials follow. You're good in your subject, money follows you. You are average in your subject, money still follows you because you can convince the judge. But you don't know why you are reading that subject, you are getting frustrated and you will never excel. This is how we classify the journey.
You need to have great memory to remember so many sections, so much content, right? So, how do you actually manage? This is so much actually.
Memory is something which is with everyone. We are no special species on the earth. Lawyers also are average human beings who have normal memory skills. Now, the point that is to be understood is interest results in you to memorize. Let's put it very simple. You like a song. What do? Rewind, play, rewind, play, rewind, play, rewind, play. After some time, you remember the song. Leave it for 5 years. Suddenly, someday when you're walking, you try to hum that particular song. I will vouch you will get the full song in random access. This is the power of interest, which has caused you to remember that particular subject. Memory, God has not sent people with 1 kg of brain with one person, 10 kgs of brain with other person. Brain's size, weight is same with everyone. The neuro strength of every human being is directly related to the areas of interest which the person is. A scientist remembers data. A person who is an athlete remembers the range in which the person has to fight. A singer remembers the swaras. A musician remembers how it has to come out of that particular musical instrument. A lawyer remembers acts and facts. Is the interest. Because you are interested, knowingly or unknowingly, you revise. When you revise, your memory is as fresh as you read on day one with full, precise knowledge. Now, what is important here is in your random access, when you are actually, why for advocates or stage performers. Advocates are also, I can say, in court, it is our final stage. We're given 2 minutes or 3 minutes max to talk about our application in High Court. Now, in this 3 minutes, I am supposed to show my judge where that particular case lies for an order to be given. Now, I have already gave in my petition. My petition could be about 40 or 50 pages. Now, my judge does not have 50 pages reading time in his call list. So, what do? I see that I guide my judge to those specific pages and those specific paragraphs which are of interest to pass an interim order to me. When it's a final argument, I make sure that my judge runs through the entire case with respect to the issues. Now, this is what we actually do. For this, what we need is we need to research on the case. If people see, I've seen many people who are motivated by our Hindi, Telugu, and English movies. They see advocates in 3 hours, case is solved, and it's going to be a happy life. But in real time scenario, 3 years is nothing. Forget about 3 hours. 3 years is nothing. So there's a court time. And in a country like India, where we have 140 crores of population, and where we have almost 140 litigations that come up every second in a state, the number of pending cases are bound to go up. Now, keeping this in scenario, judge giving half an hour to 40 minutes time to each counsel is a dream. It's not a reality. It will never happen. So what are we supposed to do is prepare ourselves for the next day. Courtroom is the final, the end 2 minutes clip. What you do is the background, starting from understanding the case, drafting the pleadings, preparing for your arguments, go and present your arguments in front of the judge. All in the blues, judge may say, I have never seen a case like this, so you have to bring precedents. So much of work is required. So if you have 10 hours of time for a particular case, it's only the last 10 minutes which will be in the court. The balance 9 or 15 minutes is with you in the office for preparing for that particular case. Now, this is where a person has to understand the demand of the profession. And we are there in the court from 10 to 5. So, where is our preparation time? 6 to 9, or maybe 6 to 10, or if time demands, your night stretches. So, we don't say it is a tough job for us, but it is a job which we have chosen for ourselves. Now, when you choose, you don't find the pain in it. When you don't choose, obviously you will be cribbing the whole life. So, in a nutshell, Memory is because you are interested. Memory is not because you have that faculty separately built for you. It's a developed skill. It's not an inbuilt skill.
Yeah. So, what is your specialization?
There are three areas which I have actually specialized. I mean, rather than saying specialized, I can say I have seasoned myself. Now, what's the difference? Then we'll talk about how it applies. Specialization is something which you have acquired, you have projected yourself to have acquired through some qualifications. Like someone has done PhD in macroeconomics in international currencies. Now, this they can say it's my specialization because they've submitted some thesis on it and the thesis got approved by a university. In law, there is nothing called specialized area. It is what we call as practice area, where I prefer myself to represent the court. That's what it is. And every advocate will get an opportunity to choose. Now, I have chosen, first I started my journey with something called white collar offenses. Because I have some interest of looking society as a better society. Now, when do you see a better society? You see a society to be better when it does not have certain parameters. If I were to take the Viksit Bharat vision, Viksit Bharat basically focuses on something called eradication of multidimensional poverty. Now, what is multidimensional poverty? Tap in a house is also considered as a poverty line. You have a tap, or you don't have a tap. You don't have a tap, it's below poverty line. Gas cylinder, it is also a parameter of analysis. Drainage, parameter of analysis. Over a period of time, if you see Swachh Bharat, toilet constructions, everything was trying to have a focus on multidimensional evaluation because certain facilities earmark you to say that this country is out of the poverty line. It is not just per capita income of a person. Now, having said that, when we choose based on something called one, my faculties, what I'm interested in, two, where the journey is going, three, my focus towards society. I never thought of having a crime-free society because crime dimension changes. 30 years or 40 years back, you had people who used to break the wall, enter into a particular place, steal things from there. There are experts in police who could identify which gang it is. But that knowledge today is obsolete. Why? Because people are not interested to break walls anymore. People are interested to break only cyber walls now. And a cyber wall does not have any physical exercise. It's an intellectual exercise. So that's where your subject has changed. So now, I initially started off with something called let me help the society by getting entrepreneurs more. Way back when we are talking about 2003-4, what was more required is from employment there a shift started of having an entrepreneurship. Journey went in various ways from 2014 to 2019. Many startups came, and there were huge changes that were happening. Now, in this journey, we started giving something called business consulting. Now, where the whole focus was, if you see people in 2012 to 14, they were more interested in the schemes given by the government. How can they explore that scheme, raise funds from that particular scheme, and do business activity? So, if you see the psychology of the society at that time, it was more debt-raising psychology. At that point of time, financial markets also did something called debt syndication, equity syndication. We helped many of our clients getting this. But then I realized that what is missing is the compliance. When you do business, you generally don't keep an eye on compliance. Now, when you don't keep an eye on compliance, penalties shoot up, cases shoot up, so on and so forth. Then I realized that, okay, it is not just consulting people to raise money. What we have to also consult is how do they manage their business affairs. So we started giving that as a service. Now, when we saw this happening, there was fight between partners.
Yeah.
So when you have 50,000 rupees of revenue on a monthly basis, talking about 15 to 20 years back, 50,000 is a great money. Today it is nothing. Today it's what you can't even say your single month also with 50,000. That's how things are. Now at that point of time, when the revenue was about 50,000, by and large with about 5 or 6 employees, it was okay. But when turnover raised, business went up to say 10 or 15 lakhs. There was a dispute between the partners. Why? It's nothing to do with those two. Something to do with something called human psychological focus. Everyone feels self-important. So are we. I am also feel self-important. But between partners, when you get this feeling called self-importance, each of them or all of them will feel that they have done a great job on this trademark. This is the basic cause of attribution to the turnover. What missed between them is demarcation of responsibilities and demarcation of activities. Since that did not happen, everyone feels that it is they who solely contributed for the turnover. Hence, they want the business to be owned by them. They try to purchase stake of others, or they try to play with others to get that stake. Result is company gets into the hands of a single person who practically knows only one angle of the business, and the business collapses. Having seen this, we thought, okay, now what is more required is a cohesive atmosphere where such disputes can be talked. That's where we thought of starting. We started something called mediation and conciliation centers. Now, I always used to give an ear to both the sides and say, look, you are right in all this, but this you did not do it right. Now it's the way you say it also. If you say you have done this wrong, no one will listen to you. Out of 40 different things which are done wrong, there will be 2 things which the person has done right. Say these 2 which he has done right.
And then start with.
Say 3 which he has done wrong. Repeat these 2 which he has done right. Okay. Then say again 4 which he has done wrong. Okay. Convince him that 40 he has done wrong.
Okay.
But the 2 which he has done is right must have got some business activity to the business.
Yeah.
So you have to justify that person and say, because of this goodness of yours, business has got this activity flourished. So is the case with others, so is the case with others. Now when you integrate all this, we call this conciliation. We have actually explored all issues, identified strength of each person, brought those strengths on the table, made all of the stakeholders understand their strength, and then give an agreement and say, buddies, you can do this extraordinarily well. They are convinced. The result of this is the business entity has stabilized. Because now they know what they are good at. 2, they have a document which has demarcated what is each activity, what is each responsibility. And finally, this document will become their future partnership document or future memorandum of understanding, whatever we call it in business. This is what is missing in the society today. And this is what we are trying to address to the society. All disputes, if we leave it to the court, maybe that institution will collapse. If we really have certain provisions, whenever we prepare agreements, we always feel that someday this particular agreement will be read in courts. That means a dispute is expected to arise. Now, if it arises, we fix something called stages. Don't start off and fighting. Don't come up with a case straight away. What you are expected to do is go by the agreement clause. First, it says when a dispute arises between the partners, let's go for mediation. It fails, let's go for conciliation. It fails, then we'll go for arbitration. If it further fails, then we'll go to the court. We've given a stages in the agreement. And this is sent to the people. We have a software where every partner is aligned in it. Every partner will comment on that particular agreement. And we will make finally an agreement for which we have a repository. Whenever they come and fall back and see the agreement, they will understand that, okay, this is the correction which that person has said, and finally this is the agreement which we have agreed upon. We are using technology. Former, it was a scenario where we used to draft, redraft, send, So much of trees we used to waste in the name of paper. Now today everything is in a digital space where it is easy for review, analysis and repository. So we see that the cohesiveness in the ecosystem of business has improved substantially across the country because of this type of activities. But still, certain disputes go to some extent that it is difficult for them to come back. So they struggle in the courts.
So, what is the duration of this mediation or conciliation? I mean, any tough case that you had in your experience?
Mediation generally we look in for about 6 months. There will be about we can say about 3 to 4 meetings in 6 months. Former mediation we used to do in hotel rooms or conference rooms. The challenge which we used to have is recording. Human mind does not accept what is against it. So if a person has said something in a particular meeting, and in the second meeting, the same thing you say, you said this in the previous meeting, 99% he will say, I never said it. 99%. 1% he'll agree. So you need some tool or you need some evidence to say that you have really said this. So that's where we say mediations are audio video recorded. And we inform the client, look, mediation is audio video recorded. And at the end of it, we make a summary. This summary is given. So classically in 6 sessions, which we can say spreads across 6 months, mediation should be done. It fails, then either it will go to conciliation or it will go to mediation. Generally goes to conciliation for closure, or it will go to arbitration where the time is 1 year. That's the Act says, Arbitration Conciliation Act says you should do it in 1 year. There are cases where 4 years also arbitration is not done. There are multiple reasons for it. I'm not talking about aspects, I'm talking about what is ideal scenario. 1 year is something which is a good time for arbitration to be done. Where there's a claim, there is a dispute, there's a discussion, evidence is led, and the tribunal gives an award. You're not happy with that particular award, you can go to High Court. But then High Court will only address the award from what is there in the award. It will not take fresh evidence, unlike any other case. So this is where we see mediation arbitration to be successful. Because classically, if you see a civil case, ideally it should take 3 to 4 years. Any civil case. It's a court procedure. We have time for written statement, then we have time for arguments. If there are any IAs, those IAs are heard, then issues are framed, plaintiff evidence is completed, defendant evidence is completed, arguments happen, judgment is given. Now, since there are many cases, the time between each date will be at least 3 months. So, if 4 dates are given, classically you have lost a year. 3 months, 4 dates, you lost 1 year. So, that makes a civil case to run about 3 to 4 years. There are civil cases in my experience which have taken 7 years also.
Okay. So, you take a civil, corporate.
In a nutshell, what challenges me intellectually is what I take, but as an office, because it's not me who is taking, it's the firm which is accepting. Now, when the firm accepts, firm has cost, firm has overheads, and firm has regular expenses. So, firm as such accepts all cases because after it picks up a case, it is allotted to the partner who has that practice area. Corporate laws I do, cyber laws I do, arbitration I do. Family law, conciliations, there is another colleague of mine, another associate with us. Criminal defense we choose, but then there are colleagues who handle it. So it's like that.
Oh.
So when you're doing it as a firm, you have the luxury of assigning it to people. When you're doing it individual, then you become a criminal defense lawyer or you become a corporate lawyer. It goes by the court where you are regularly seen.
Right.
And knowingly or unknowingly, we are seen everywhere. So it is difficult to say what we do. But per se, as an individual, I prefer looking into corporate law issues, tax matters. And I'm also interested, my interest, because since we started our journey with disputes as well as crime, obviously my investigation skills are more with respect to understanding a crime, be it a good old age-old system of crime or a cyber crime or a white collar offense. Today, white collar offenses has broadened itself called economic offenses. So we have economic offenses, which we classically are interested in. We are also focused on corporate laws. Any corporate matter I take up, tax matters I take up, and not the least, I also look into property, civil law. But I have less experience in civil law. But whatever I have, 5 or 6 cases which I have done it to the satisfaction of me.
How long do someone have to take the internship, the duration?
The university in its course says you should have, I guess, 4 internships, or some law colleges say you should have 10 internships in your legal career or in your law school. And ideally, they give 30 to 45 days time for an internship, is what I've seen as a curriculum. But to my understanding, 30 to 40 days, you don't even understand one provision of an act. What will you do as an intern? I'm not discouraging, I'm encouraging actually. When I say you cannot read an act, it means that you can read one section. In that one section, you have to explore during your internship. So internship, rather than choosing the office, you have to choose the practice area which you are interested in. And you inform to the person where you are trying to get interned that, sir, this is the area. Let's say you're looking for about Negotiable Instruments Act and you want to learn more about 138 cases. Read with 142. Go to a counsel who has some variance. What I mean to have variance is, you can ask them, say, I am here to learn the intricacies of 138 case. During this period, I presume there could be a possibility where one of your case you are filing, one of your case is your in between arguments, and one of the case may be in the closing arguments. You can see that I'll get experience of that. It could be a request, but then more than the request, when you go to a counsel, they also try to explore your consistency levels. How much time you can sit in the court, if I give you a work, whether you do it or not. So first you have to gain confidence of the person whom you have chosen as your principal for the internship. If your principal finds that you have that zeal and you can be taught this particular knowledge, then you open up this conversation and say, sir, my learning journey, I want it to be like this. So in your 30 days of time, maybe for first 15 days, you have to explore this option to gain confidence of your principal. And the next 15 days, your principal has cases, so he can put you at various courts and see that you get the experience. So first is the confidence. Now what can be a leverage is you can ask your faculties to say, because they know already the advocates who are in the market. So they can guide you when you say that this is your requirement. They can guide you to that particular office which has that practice area, and you can learn from that particular practice area. Classically, what I've seen in last 5 years is people come, they enjoy the air condition of the office, they pretend to be reading books, and they go to court, they come in the evening, they go home. We have seen 20 years in courts. Can't we understand what they are doing? This, the upcoming lawyers must understand. I'm going to a person who has 20 years experience, who has seen the court walls, the same court walls for 20 years. If I go and see the walls, he will also tell me when it was painted, when there was a crack in it. That is our accuracy. Now, if the person comes to us and say, I have been in so-and-so court, in the 2 minutes of discussion, we can decide whether he has sit in the court or not. This is what experience has taught us. And the unfortunate thing in today's people is learning is more focused on digital platforms. Learning is not focused on the arguments which people are learning. We have seen in YouTubes and Instagrams many of the courtroom videos being presented. There's no learning in it. It's only the dramatized part of the court which we see. If you really want to learn, what is required is sit in that courtroom from morning 10 or 10:30 when the court starts till the end. One case, if you are really able to see an argument for about 5 minutes, which you have really learned of it, that satisfies your whole day. Now, when that one case will come, we are not sure. We were not sure when we were sitting. And we sit every day to learn something new. This is what a prospective intern must always keep in mind. My learning is not confined to the courtroom, not confined to my senior's chamber. It is confined to my intellectual research mindset. So when you have that mindset, you don't mind teaching. Now, when you try to show off, we also equally do that because we are helpless.
Do people have to have good networking skills to hit the job market in law?
See, there are two different things: networking and job market. Now, when I say networking, for me, networking is attending conferences, gain knowledge from the experience of other people when they come. Eventually, when you attend conferences, you also meet people who could be like-minded people. Now, that like-minded people will actually increase the horizons of your profession. When you say job market, we are actually talking about what the companies are looking at from law graduates, to my understanding. First, I'll talk about what my firm looks at, then I'll talk about what could be the possible angle of the company. Now, whenever we are taking up any law graduate or any advocate into our company or firm, we look at something called research interest of that particular person. Some people are very good in courtrooms. They are interested in court works. They're not much interested in research works. So we make sure that they are in the courts from 10 to 5. We try to assign multiple courts to them so that they are happy in the work which they do. They're happy talking to the people in the section. They are happy getting the documents marked and stuff. This is one attitude, mindset of a person. It's they are happy wearing the gown every day. They want themselves to be seen in the barrister hat. It's one segment. Second segment, they want to research. They want to give some logical conclusions. They want to study cases, study judgments, interpret between law, come to some conclusions on a particular aspect. These are research-oriented mindsets. They're not much interested in courts. Research-oriented mindsets, we have a separate wing called Legal Research Associates. We don't expect them to go to court. We definitely expect them to sit, churn out cases. Like we say, let us say we talk about penal provision on Income Tax Act. There is an income tax notice that has come with respect to a penalty that is going to be levied on interest. Now we have to decide whether it is liable to be paid or not. For this, person has to read the act. Person has to read any precedents given by the High Court, any judgments given by High Court or Supreme Court against that particular section. Sometimes it so happens, if you see Companies Act from 1956, the act was repealed as 2013. So what was section 25 in 1956 Act is section 8 in 2013. So we should understand this connectivity. There could be some judgments in section 25, there could be some judgments in section 8, but the point of law which is being debated upon is same. Only section has changed. Now this, the Legal Research Associate is expected to give a summary report stating that for the case which we are talking about, these are the judgments which are favorable to us. These are the judgments which we have to look upon to convince the judge that my case doesn't fall in this category. Because when you say that my case falls in the category where a judgment was rejected or disallowed, then we are at loss. So we are supposed to take both sides, because generally when we are arguing, those cases which I am avoiding to present to the court, since they are against my wish, I am 100% sure that the counsel on the other side will bring those cases. So what I prepare myself is, if I have 10 cases which could give me a favorable judgment, 30 cases which could give me an unfavorable judgment, I go through 30 cases more times than my 10 cases because I know that I'll pitching them. But what I have to see is what is in my case that ensures me that I don't fall in this 30 category.
So people who pursue law, uh, do they have, if they don't want to practice and then get into specialization, what kind of jobs can they take up?
Every company which has raised, let us say, for about 50 crores of turnover will look for a dedicated legal team for itself. Now we call them as employees on roll for that company. They will be given a designation called either legal officer or compliance officer or whatsoever. They are as good as any employee in the company, but what they will be focused is the agreements which the company has to sign, documentation which the company has to maintain, correspondence which happen with other people. This is what they ideally do. Qualification for this most preferred is a law graduate because it also have an ease to communicate whenever there is an issue. Since they are not enrolled with the Bar Council of India, they can't represent in the court. But whatever is the factual information with the company, I, as a counsel outside, I will not know what correspondence the company did, and I will not have the entire picture. They have the picture. So when we are discussing with a particular correspondence, they may say, "Sir, there was an internal correspondence also in the same subject matter. We have also sent separately mail from our accounts team." That information I will not know. So it is for the person who is inside the company as a legal officer or whatever designation called, they will work out. These are as good as any other employees, but they will be catering to the only legal space of that particular company. If the company goes up, team also goes up. It could be a single person, it could be about 10 or 15 people, or spread across the whole country, whatever be the scenario. This is one segment. Every corporate will have. Banks have exclusive legal domain. Now, there is a separate department, we call it as legal department. Some they outsource it to us. Some will be vetted by the bank itself. Like to give a property title research report, it is a cost. So a dedicated team of the bank, which is called a legal team, they will do the preliminary research first. When they feel that, okay, this particular loan we are positive on giving it, then they will give it to an external counsel to get a legal opinion. So their internal legal opinion plus the external legal opinion put together, they decide whether to lend that particular money or not. If there is a recovery issue, then the internal legal team of the bank will coordinate, find out, see when is the time ripen for the purpose of evaluation, and then they shoot the notices and all. Okay. So banks is one area. Okay. Every company is another area. Then you have every company which is listed. It needs to have a separate legal team. That's a requirement of stock exchanges. Okay. So that particular department also people can join. All this is for those people who are not interested in coming in courts. See, every person who is doing an law graduation need not have the interest of arguing in the court. Okay. So they can be a legal research associate in a advocate's office. They can join the corporate, become law officer or a compliance officer. They can join in a company which is listed, be in the legal team. They can join in banks. Insurance companies also look for it for surveyors and issues related to evaluation.
What do these company secretaries, is it the same line?
Company secretaries are exclusively confined to Companies Act. So they do something called secretarial practice.
After law graduation?
Company secretary is a separate stream.
Okay.
Law graduation is a separate stream.
Okay.
So law graduate can also do company secretary, but in India we have a rule: you cannot exercise two professions at the same time. So if you are employed, you can neither practice company secretary nor practice law. You are an employee of the company. Or you can practice company secretary, have a law degree. Or you can have a practice law, have a company secretary degree. Okay. You can't have both. Okay. So ideally it is where you want to exercise your profession. You want to exercise your profession before courts, it's enrollment with Bar Council. You want to exercise your profession before ROC and Regional Director for Companies Act, Company Secretary. You want to exercise before income tax authorities, Chartered Accountant. You want to exercise your profession only as an employee. You don't need to take any practice. With that degree, join the company. Okay. It's as simple as that. There are opportunities. It's not that opportunities are not there.
And other thing, the moment a person gets qualified, he can join the bar council. He can also write the judicial exams. There is a need for good judges in the country. So they can also become a judge. But responsibility, apart from responsibility, honor is there for the judge. Advocates have responsibility and reputation. Here we call reputation, there we call honor. Because the reputation of a judge impacts the judiciary.
Okay.
The reputation of an advocate impacts the advocacy practice. Now, judiciary is seen differently. So, it is marked with additional respect. Hence, we say honor is at stake.
Okay.
We don't say reputation is at stake there.
Okay.
Because it has the additional respect.
Okay.
That's how it is. So, these are the options available. And any person who is doing law has all these options available. Now, once they choose their interest area, then they can explore where they fit. That's where it is.
Okay.
It's not that I should have the feel of going to the court. Down the line, maybe someone who is employed, after interacting so many, people get motivated by someone whom they see and get connected. And this person whom they got connected ideally becomes a role model or ideal person. I've seen people who have joined employment in companies, see some senior lawyer, like the way he has presented the case in the court. Time and again they find opportunities to meet that senior counsel, and eventually they resign, join bar council, get enrolled as advocate, start practicing. Unknowingly, this person who has presented the case well before the courts became role model of that person. And that person is motivated, joins the stream. It's called a change in profile, which events have taken, that we cannot vouch. That is a event-driven choice. The first one is a personal choice. So both are important for a career building. So that's where things go on. So that's from a career side. Now, once a person gets into, there is another segment we call it as public prosecutors or government leaders. You are representing the court on the criminal side of it, you call a public prosecutor. You are representing the court on the civil side of it, you are called a government leader. But both designations are, you are actually addressing the government to the court. So you represent the government. Say I'm the central counsel, standing counsel if someone says. So the central government standing counsel for some department. So whenever there is an issue, he will talk to that particular department, get instructions from them, submit to the court, represent that department to the court. So that's how that said government pleader will be working out. There are exams for it. People can write and then pass. So choice again. You may be motivated seeing a government pleader. I want to become a government pleader. Okay. Public prosecutor. I want to become a public prosecutor. Fine. But I have seen people also who have seen movies. They like the movie, the way the actor has argued as an advocate. Try to become an advocate. But then after some time, what happens is, this gets faded off. Why it gets faded off is, see the vision. It's a 3 hours movie or 2 hours movie. Today we don't have time to see a 3 hours movie also. 2 hours movie where you see the problem and the solution being given in 2 hours by a counsel who has motivated him on the screen.
Yeah.
In 2 years also, if that does not happen here, we are bound to see that the motivation is faded. This is what we call as a start struggle motivation. Doesn't last. They have to check, or else they get disappointed.
So we are seeing that artificial intelligence is impacting a lot of job roles. Is it having any impact on law and legal profession? How is it?
Artificial intelligence is a tool. Every tool will benefit the society, provided you know how to use the tool. Now there was a dispute, there was a discussion in the courtrooms also, which says, can artificial intelligence replace the judiciary? Artificial intelligence will help the judiciary, it will not replace the judiciary, because to be a judge, what is more important is compassion rather than technicality. When you see any provision of criminal procedure code or any provision of IPC, penal codes, The provision always says it is 1 to 7 years or 3 to 10 years, 5 to 15 years, life imprisonment, up to life imprisonment. So it's always up to. Discretion is given because there is a human interface. If judge is replaced by an artificial intelligence will give like this. Okay, so and so road accident, so and so person has lost his one limb. What does the provision say? 4 years imprisonment, 2 years rigorous imprisonment, execute, that's it. Artificial intelligence is not expected to have compassion because it's a machine. How can a machine have compassion? But the judge will have a compassion. Judge will also understand during the trial, was there an impulsive action? Was there a deliberate action? Was there an action which was having no control on the person? There could be a scenario where an accident has happened because someone suddenly has developed fatigue and the person was in driving seat, because of which the vehicle was uncontrollable. It goes and hits the person.
Yeah.
Now, if my medical report of that particular claimant confirms that there was a fatigue at that point of time, genuinely the driver in the seat did not have senses of what was happening, the accident was uncontrollable and has resulted. Now, this compassion may give lesser sentence, may acquit the person.
Correct.
Because it was not an intentional activity.
Correct.
This, howsoever you program an artificial intelligence, it is artificial.
I know.
Hence, the result also will be artificial. So, it cannot replace judiciary. It can help the judiciary in taking a better decision, learning the precedents well, having a good research, giving a better judgment. The first advantage which artificial intelligence has given is glorifying presentation. You write something which goes into 500 words. You speak to artificial intelligence, say improvise. If you see today, LinkedIn also says improvise with AI.
Yeah, I know.
Now click on that, it will rephrase everything and give you a glorifying phrase,
Yes.
a glorifying paragraph, which you also will be happy. Readers will be happy. Now, this is the help which artificial intelligence can give to the judiciary. One is research, second is fact check, third is concise judgment, which hitherto I may not have thought of. I could have written the paragraph which is 500 words into a 50 words. I may try, but I am not expected to achieve that fast. So, what personally I expect is, we can expect a concise judgment to come, which fully identifies the facts and which also addresses the legal points. And since it is given by a human judge, it will have that compassion to it. So that's where we can see it will enhance the judiciary in its task when it comes to advocates. Now we have something called judicial findings always. If I have a case which is with me in the state of Telangana, there could have been a similar case which is dealt in the north side of the country. It could be somewhere in Madhya Pradesh, similar crime must have happened. By and large, similar facts may have happened. There could be some judgment in which certain events has given conviction to the culprit. I am searching here. So if I have artificial intelligence, which churns the entire database of India, finds this case to me, I can correlate the facts, I can present my case better.
Great, yeah.
And I can also give a circumstances which says, there this has happened because of these events, but here these events don't exist.
Okay.
When does crime happen? When there is an imbalance in society, or when there is an excess greed factor. Someone is more greedy, person would become a theft or do a cybercrime or whatsoever. Crime's root is guilt of mind. If there is a guilt of mind, it gives birth to a crime. If there is no guilt of mind, it doesn't give birth to a crime. Now, accident, there is no guilt of mind here. We are saying accident.
Yeah.
You don't expect it to happen, but it happens.
Yeah.
Now, circumstances that say that this particular facts have been done. Now, in accident, generally what happens is claim. Now, motor accident claims, we always see as to some calculations. There's a chart given in motor accident tribunal claims. So, one limb so much, two limbs so much, person is unconscious so much. So, we have a chart. Now, this chart from the date of accident till the claim date, there is some interest calculation. Insurance company will say this is disallowed. Our job as the counsel for the victim is to see that it is allowed. So we can use artificial intelligence for the purpose of calculations also.
Okay.
Feasibility of calculations, and inform the judge that this calculation is more feasible than what insurance company is giving.
Okay.
And this is the reason why I believe these calculations are good. So it helps you in fact check, it helps you in calculation, it helps you in presenting the case. More so, it helps you to understand appropriate legal precedent pinpointedly in the paragraph of the judge. This is how I see artificial intelligence for advocates.
How does the future look like for corporate law in terms of opportunities, challenges? How is it?
Corporate law is that branch of law which studies about companies or help companies to actually excel. Now, this corporate law we add with a couple of other associated or allied areas. We also call it as intellectual property laws. Then we also have something called compliance, which ideally the Companies Act, Provident Fund, income tax and all this stuff would come. So corporate law today is a basket of 5 or 6 variants. Now all these variants put together will come up from the point of view of where is the growth trajectory of the country going. If the growth trajectory of the country is going in the overall development of the industry and the building of a corporate ecosystem, then we expect the professional growth also to happen extensively. Howsoever a person tries to be compliant, there could be some things that could miss. Now today, whatever is expected to be missed, we are trying to have an addition called tools. There are a lot of ERP tools, be it for corporate, be it project management, you have tools. For task management, you have tools. For to-do lists, we have tools. Presentation has increased. So when you say corporate law, it is a mix of all this. Now, I am starting, as a corporate, we are starting a new research center in a government allotted space. Let us presume we are talking about a pharmaceutical company, where the pharmaceutical company is planning to start a research wing. Now this research wing will have a building to be constructed, compliance on obtaining approvals for the property, then you recruit people to do the project, then you have a compliance issues on the recruitment, appointment letters, how you have to terminate the person, what are the events of termination. All these come under the segment of corporate law. Classically, if you see, the area which we have discussed just now is construction of a building. But since a pharmaceutical company is doing this particular construction, a corporate lawyer is pitched in over there. Because there is a lot of legality that's coming out.
Good.
I need an approval of the income tax department with respect to the expenditure which I have said. Department says disallowed. I say it is allowed. So a lawyer will be working out. You may be working with a chartered accountant, but documentation is with the compliance team. And there is a lawyer in the compliance team also. So we don't say that corporate law today is confined to Companies Act. Corporate law is confined to, let's say there is a trademark. We have a trademark research that happens every day. We may have a company which is using a common name or a similar name.
Yeah.
Like today, phonetic names are very common. I have seen some place, I think near Uppal or so, I saw a restaurant being named in exactly the font color of Google.
Even I have.
But that fellow has figured out LL or EE something, instead of make it Google, he made it Googly or something like that.
Yes.
But the first glance which you see, you find it to a Google corporate office. The logo will give you an indication that it's a Google corporate office.
Yes.
But when you carefully see, you understand it has got nothing to do with Google. It's just a restaurant which has used the same color, font and size. Now this is called a trademark infringement.
Okay.
If Google knows it,
Hmm.
then they can file a suit of trademark infringement. Many a times it happened. You had Karnataka soaps, which Mysore sandal soap, which is very common.
Yeah.
There was another company which has used a similar brand, similar style, similar space. Now Karnataka soaps has filed a trademark infringement on it. Then that case went up to Supreme Court, and finally they are restrained from using that particular logo. Now these are the developments which in the corporate lawyer segment, you are in copyrights and trademark infringement side, you are monitoring the trademarks and copyrights of your company, and you always are vigilant to see that someone has used it. Now let's presume if someone from Google Law Office or Google Law Department actually sees this particular logo, then they will strike, take that fellow's address and send a notice. Till then, that will run. Now, you don't know how the presence will be, but yes, because of AI, because of expansions, because of globalization and privatization, the world has become a small village. Now, in a small village, everyone trades. Everyone wants to maximize profits. Everyone wants to see that this maximized profits is in a legal framework. So when this is true, the journey of increasing scale of professionals required for corporate law, per se law, goes up.
Good.
Small entities have anyhow, they don't need such great service. Small entities will be, let us say a small supermarket is operating. Maximum that fellow will have a recovery issue.
Okay.
He will not hire a lawyer for a supermarket. Whenever he has a recovery issue, he will come to a counsel who is into regular practice. But his corporates are looking for people who extensively do the research work. So that's the difference. That's a profile which has scale. Now, whenever I am choosing something as a career, I want it to be profitable. And no one wants a salary to be stagnant. People want salary to go up, quarter duplicate, year on year. That's the dream at least. Now, what will really happen, that's a different story. But you want salary numbers to be, every year you want 1 zero to add at the end. So if that is a scenario, there is a possibility in the corporate world. In a standing profession also, it is possible when your number of clients go up. If your number of clients scale up, your turnover goes up. Rules of basic finance. When your turnover goes up, if you make your expenses reasonably at a lower level of increase, then your profits are at a higher level. As simple as that.
Correct.
That's where it is.
Nice. So we had deep conversation today, and then hope the viewers have intense information on legal profession. Thank you, Moksha. Thank you so much.
I hope I have given some good insights.
It was indeed. Thank you.
Thank you so much.